Chapter 3, the Prize Court and Prize Law. When an eminent man has been in his grave for 80 years, posterity in that space of time has generally assessed his career and his work at their true value. History is strewn with examples of the inaccuracy of contemporary estimates, and the opinion formed of Stowell by the men of his own generation is yet another instance of this statement. For if one had asked one of his contemporaries upon what his reputation rested, the answer certainly would have been that it was due to his learning and experience as an ecclesiastical lawyer. Posterity has finally and decidedly formed a different estimate of Stowell's historical position. As an ecclesiastical lawyer, he was the advisor of officials and of private persons. As such, he held several important ecclesiastical judgeships, and in his judicial capacity pronounced some interesting and valuable judgments. In a legal textbook, these decisions must necessarily be enumerated but as we approach the end of a century from Stowell's birth, to us who stand at a long distance from the period of his professional and judicial activities, these judgments are no more than personal indictments in his judicial life, evidence of his capacity in one of his several spheres of work. Some of these decisions have, it is true, become in lawyers' language leading cases in matrimonial and probate law, but in spite of this fact, for us they are dead, and their individuality is merged in a mass of subsequent decisions and of statute law. In some degree, but to a lesser extent, oblivion has clouded the individuality of Stowell's purely admiralty decisions, or, as they should strictly be termed, decisions on the instant side of the High Court of Admiralty. The qualities and characteristics of Stowell as a judge in the prize court, and the unique circumstances which occurred at the time he held that office, which make his tenure of it permanently remarkable, were present in some degree in relation to his admiralty judgments, and of these an impression is given in a later chapter. But whereas the prize court acts only in time of war, the Admiralty Court sits year in and year out, and in the long period since Stowell resigned his office, a large number of decisions of his successors, of the Judicial Committee of the Court of Appeal and of the House of Lords, have completed the structure of which some of Stowell's decisions may be regarded as cornerstones. It is therefore on his work as judge of the prize court for 29 years, and on that work alone, that the universal fame of Stowell, which posterity indubitably rests. Before, however, we turn to Stowell and the prize court, it is desirable to sketch first of all, in a few lines, the nature of the jurisdiction exercised by the prize court in the 18th century. The first fact to bear in mind, as Stowell himself pointed out, is that all rights of prize belong originally to the Crown, and the beneficial interest derived by others can proceed only from the grant of the Crown. It is under this grant to ships of war, and, in the 18th century, to privateers, evidenced by the issue of a proclamation at the commencement of every war, that vessels forming units of the Royal Navy, and privateers to which letters of marque had been issued, were entitled to those ships and cargo which they captured during war, and which the judge of the court condemned as lawful prize. Another large class of prizes was known as Droits of Admiralty. This arose out of the ancient grants by which the Crown ceded a portion of its rights to the Lord High Admiral. They were, once for all, expressly defined by an Order in Council of March 6, 1665 to 1666, and briefly stated, comprehended all prizes captured during hostilities, either in port or by non-commissioned vessels or persons. A third class, droits of the crown, should also not be left out of notice, comprising captures effected by a conjoint force of the army and navy, as on the seizure of a man's enemy's colony or possession, and captures made before the commencement of hostilities. For an embargo or stop was often placed on vessels of another power which were lying in port before a declaration of war, and if hostilities ensued, these vessels and their cargoes were proceeded against in the prize court as lawful prize. The distinction between crown droit and droit of admiralty became of historical interest only after 1702, when Prince George of Denmark, then Lord High Admiral, surrendered the droit of admiralty to the crown. But the distinction between captures under the grant of the crown and captures which, it was alleged, were droit of admiralty, had, when Stowell was judge of the prize court, a real importance, and often gave rise to warm disputes between the captors and the government, which now possessed the rights of the Lord High Admiral. Some of Stowell's most luminous and lengthy judgments were delivered for the purpose of deciding these opposing claims. Another important branch of prize jurisdiction was concerned with disputes as to joint capture, differences between rival ships of war as to whether this ship or that, whether one of the Royal Navy or a privateer, was entitled to a share in a prize. These contests between admirals and captains, subordinate officers, and the crews gave rise to legal disputes, which seem inappropriate to such differences, and to quite a series of decisions on the rules which should guide the court in allowing a vessel to take a share of the booty in the hands of the court. Such picturesque, if perhaps unedifying disputes no longer trouble the prize court today, since the captors do not now obtain any individual benefit from prizes taken at sea. There were yet other subjects for the consideration of the court, such as prize salvage, the reward for the recapture of British vessels previously taken by the enemy, and the various claims for freight, damages, and other subsidiary matters arising out of seizures of ships and cargoes. But this jurisdiction was, as compared with that of the ordinary civil court, obviously small and limited, and was therefore susceptible of receiving and retaining the impress of a single and a powerful legal mind. Before, however, one can properly appreciate the extraordinary results of Stowell's tenure of the judgment seat of the English prize court, one has also to realize the state of the law by which the prize court was guided when he became judge of the High Court of Admiralty in 1798, and when he retired in 1828. English prize law had, unlike other prize laws, been administered judicially from the 13th century, and numbers of judgments of the High Court of Admiralty were preserved among its records, as well as the decisions of the Lords Commissioners of Prize Appeals. But these judgments and decisions were no more than formal expressions of the results of the hearing in the first instance, and in others of an appeal, and did not, except in a few rare instances, contain the reasoning on which a decision was based. The latest of these documents differed little in form from the earliest, and as they were not usually supported by recorded judicial expressions, they were useless as precedents. A few isolated cases, it is true, had been chronicled, as for example by Sir William Burrell, an advocate of Doctors' Commons, who collected a number of decisions in the High Court of Admiralty, and of the Lords Commissioners of Prize Appeals, which extended from 1758 to 1765. And there were also a few decisions, more fully reported, of Sir George Hay and Sir James Marriott from 1776 to 1779. In the notebooks and in the memories of the advocates of Doctors' Commons, precedents also existed which were utilized both by the advocates and by the judge. But they were hardly more than legal traditions, often liable to be misunderstood, for they could not be accurately verified. A remarkable instance of this vagueness of the traditional precedent is the case of the med guds helpae, pronounced probably terribly, decided by the Lords Commissioners of Prize Appeals in 1778, by which it was settled that the pitch and tar were absolute contraband. This was referred to by Lord Stowell in 1798 as the famous case of the med guds helpae. The manuscript notes, which I have of that case, he continues, expressly state it, the cargo, to have been condemned on the ground of contraband. But it was not till 1856, when Dr. Pratt published his book on the law of contraband of war and printed it in some manuscript notes of Sir George Lee, an eminent civilian and statesman, which were stored at Hartwell in Buckinghamshire, among others a summary of the arguments and judgment in this case, that any published report of it was available to the legal profession, and even that was of meagre and unilluminating nature. Nothing, in fact, in the nature of a series of judicial precedents having the validity of a legal code was to be found. There was a chaotic collection of law, the usefulness of which was slight. Perhaps this was not surprising when the small number of lawyers who were permitted to practice in the prize court is borne in mind. The great body of English lawyers, barristers and solicitors, knew and cared nothing about prize law. It was not a subject which interested them professionally, and therefore there was no reason why they should study it academically, for the study of jurisprudence as a science has never taken root in England, and legal study has been regarded mainly as a preliminary to the acquisition of money. The limitation of the practice of the prize court to a few civilians, which continued until after the Crimean War, has also unquestionably tended to neglect of the study of international law in more recent years. And when the present war broke out, with the old limitations removed, the prize court opened to all practitioners, and the site of the Doctors' Commons, covered by commercial buildings, it found English lawyers serenely ignorant of the groundwork of British prize law. Returning to the time when Stowell became judge of the prize court, the reader will have realized that no body of jurisprudence by which judges and advocates could be guided, or by which an administration could be assisted in dealing with foreign powers, was to be found, and Great Britain was, therefore, from a scientific point of view, without a prize law. Such was the state of things on the appointment of Sir William Scott. The absence of reported decisions not only rendered the English prize law uncertain, it also gave great weight to the contents of the various treaties by which certain points of prize law had from time to time been agreed upon by Great Britain and European powers. Administrative instructions necessarily, under such circumstances, possessed a higher value than they deserved, as expositions of prize law. Thus, in 1664, an order in council was issued which contained various rules and directions to be observed by the High Court of Admiralty in the adjudication of prizes. The second of these stated that where the ship shall belong to any of His Majesty's friends, allies, or subjects, or any of them, and shall have persons or goods found abroad, her belonging to any of the states of the United Provinces, their subjects or inhabitants, in such case, the said ship and the said goods shall alike condemned as good and lawful prize. This rule is quite opposed to the law as administered in the British prize court a century later, a fact which shows how little regard judges may have for law as expressed in administrative orders. The absence of judicial precedents produced another result. It necessarily obliged officials, who from time to time had to defend the national action in regard to maritime capture, to refer to the opinion of such text writers as they thought would justify their views. In the dispute, for example, as to the Silesian loan in 1753, Frederick the Great made a claim for compensation for damages and loss sustained by his subjects in consequence of the seizure and detention of Prussian ships by Great Britain. The law offices of the Crown, in their report or answer, relied on the authority of various writers, Grotius, Voet, Heinesius, and others on the law of nations. The English people have been bred on legal precedents. Administrative decrees and irresponsible academical opinions are therefore wholly alien to the spirit and the history of English jurisprudence. Charles Butler, who in his time was extraordinarily learned in English common and real property law, was also a skillful conveyancer, adverting to the small attention paid to the study of law of nations in England, pertinently observes in his Life of Grotius, "Is it not also because of the law of nature and nations, with all its merits, is so loose that its principles seldom admit of that practical application which renders them really useful, and which an English mind always requires?" Stowell appreciated the nature of the English mind, and at once proceeded to place the prize law of Great Britain on the same basis as, and to assimilate in character with, the law which was administered in the municipal courts of England. He impressed on his collection of international law the historical and national characteristics of English law. He placed it above the uncertainties of temporary administrative orders outside mutual international pacts. He removed it from academical discussion. He demonstrated to the world that the British prize court was a completely impartial judicial tribunal with a well-defined procedure, and that its decisions were based on a reasoned body of jurisprudence, and he completed promptly and boldly, with infinite wisdom and sagacity, the long evolution of British prize law which had begun in the 14th century. This was a remarkable and memorable achievement of immense present and future importance. With the growth of the British Empire and that of the United States is borne in mind, and fitly enough it was synchronous with the victories of the British Navy, which raised the maritime power of Great Britain to a supreme position.